Have you ever found yourself wondering what really goes on behind the scenes in those big, high-stakes legal battles? Especially, when you've got groundbreaking innovation clashing head-to-head with fierce market competition. Here on The Deep Dive, that's exactly what we do. Our mission is to cut through all that legal complexity, pull out the really important insights, and basically give you a shortcut to being properly informed. Today, we're diving deep into a really fascinating real-world patent dispute. It shows just how intricate and how strategic these fights can actually become.
Absolutely. And what's particularly interesting here is the context. It's a recent court ruling from South Africa, and it revolves around something called yielding mind support technology. But this isn't just about the patent itself. It's a perfect illustration, really, of how these seemingly small legal points, procedural arguments even, can have these huge knock-on effects, massive commercial implications for companies fighting tooth and nail to protect or maybe challenge their intellectual property.
Okay, so let's unpack this then. Who were the main players, the combatants in this legal arena?
Right. So on one side, you have Timrite Pty Ltd. They hold the patent for this yielding mind support. The patent number is 2100604444. And on the other side, you've got Vesper Projects Pty Ltd. They're a competitor, and they sell a competing product called the Vesper bag.
Okay, Timrite and Vesper. And just quickly before we get into the legal chess game, what exactly is yielding mind support?
Good question. It's basically a specialized safety device. You find them deep underground in mines. Now, unlike, say, a rigid steel beam, these supports are designed to actually deform under immense pressure. They yield, they absorb energy rather than just snapping. The idea is to prevent catastrophic tunnel collapses. So Timrite had their patented design for this, and Vesper was selling something, well, apparently similar enough to cause a problem.
Got it. So a critical piece of safety tech. What's the backstory here? Did this dispute just flare up recently?
Well, there's some history. Timrite had actually amended its patent once before, way back in 2016. They did that specifically to narrow down the scope of their patent claims. They wanted to make it clear how their invention was different from what we call prior art.
Prior art. That's basically anything that proves the idea wasn't totally new when they filed the patent, right? Like existing inventions or publications.
Exactly. It's evidence that something similar was already out there. So Timrite tried to tighten their claims in 2016, but then fast forward to 2023. Timrite decides to really escalate things. They sent Vesper a formal letter of demand.
Okay, a letter of demand, what did it say?
It accused Vesper directly of infringing Timrite's patent. And the threats in that letter were pretty serious. They were demanding things like interdictory relief. That's basically a court order telling Vesper to stop making and selling the Vesper bag immediately. Plus, they wanted Vesper to hand over all the infringing products so they could be destroyed. And they were asking for an inquiry into damages, how much money Vesper owed them, plus legal costs.
Wow, okay. So they didn't just dip a toe in, they went straight for the jugular.
Yeah.
That's a very aggressive opening move. How did Vesper react to that kind of pressure?
Well, Vesper didn't blink. They didn't back down at all. In fact, they launched an immediate countermove. They filed something called a declaration of non-infringement application under Section 69 of the Patents Act.
A declaration of non-infringement. So they went to court asking the judge to rule proactively that their product doesn't infringe.
Precisely. It's like saying, tell Timrite to back off, our product is fine. And Vesper had two main arguments. First, they said, look, our Vesper bag just doesn't infringe. It's different in specific ways from what Timrite's patent actually covers. And second, and this is a really key part of these disputes, they argued that even if their bag did fall within Timrite's claims, those claims, specifically claims 1 and 15 of the patent, were invalid anyway.
Invalid? Why?
Because of a lack of novelty and/or inventiveness. Essentially, Vesper was saying Timrite's claimed invention wasn't new or clever enough to deserve a patent in the first place. And they pointed to 3 specific prior art documents they'd found as evidence to back this up. PCT documents IB107, IB323, and GB363.
So Vesper's counter was basically, we don't infringe, and even if we did, your patent isn't valid anyway. That's throwing down the gauntlet. What did Timrite say about these prior art documents Vesper dug up? Did they know about them?
That's a great question, and Timrite's response really shows how dynamic these things are. They actually admitted they weren't aware of one of those key documents, IB107, until Vesper's expert, a Mr. Keene, brought it up in his evidence. They did acknowledge knowing about another one, GB363, back when they did their amendment in 2016, but they said at the time they didn't consider it one of the most relevant prior art documents.
Interesting. It shows how this prior art research is a constant battleground, doesn't it? New information can just pop up and change everything.
Absolutely. It keeps everyone on their toes.
Okay, so Vesper files this non-infringement claim citing prior art. What happens next?
Well, before Timrite even filed their full response to Vesper's application, they made another move. A pretty significant strategic pivot, it seems. They filed a new application. This time, it was an application to amend their patent again. They used a different section of the Act, Section 51(9), which allows amendments even while litigation is ongoing.
Amended again, right in the middle of this fight. That seems reactive.
It certainly looked that way. In fact, the judge later specifically noted, and I'm quoting here, "Objectively, there can be no real dispute that the amendments are sought as a result of the evidence contained in Mr. Keen's declaration application."
So the judge basically called it out, say they were clearly doing this because of what Vesper's expert found.
Pretty much, yes. It was seen as a direct reaction to Vesper's challenge and Mr. Keen's prior art findings.
Okay, so what changes did Timrite want to make this time? How were they trying to fix their patent?
Timrite framed it as wanting to both define the invention. Essentially, they proposed several changes. They wanted to amend those key claims, 1 and 15, to add much more specific detail. Things like describing exactly how lines of stitching form intermediate seams on the bag surface and how straps are stitched into those specific seams. They also wanted to add several entirely new claims, independent claims, 16, 18, 19, and a dependent one, 21.
New claims, too. What did those cover?
These new claims introduced some interesting concepts. For instance, claims 16, 18, and 21 talked about the strap comprising a reinforcing web constituted by a layer of fabric. And claim 19 introduced the idea of the grout bag being internally divided by a layer that included this reinforcing web, specifically mentioning woven polypropylene fabric. They were trying to add these very specific construction details, presumably features they felt the Vesper bag didn't have, or features that made their invention seem more distinct from the prior art Vesper had raised. They also proposed deleting some older, perhaps more general claims.
Right. It really sounds like they were trying to carefully redraw the boundaries of their patent, maybe to specifically exclude Vesper's product or get around that prior art.
That's certainly how it looks strategically, yes.
But I'm guessing Vesper wasn't just going to roll over and accept these changes.
Not a chance. Vesper vehemently opposed Timrite's amendment application. They came back hard with 4 strong grounds for objection, again supported by another affidavit from their expert, Mr. Keen.
4 objections. Okay, what were they?
All right, so the first one was based on lack of fair basis. This is under Section 51 of the Act. Vesper argued that those proposed new claims 16, 18, 19, 21 weren't fairly based on matter disclosed in the specification before amendment. Meaning Vesper was saying Timrite was basically trying to add new technical features or ideas that weren't even hinted at in their original patent document. Like pulling new rabbits out of the hat mid-litigation. You're generally not allowed to add completely new matter when you amend.
Okay, lack of fair basis. What was the second objection?
Second, Vesper argued for continuing invalidity. They doubled down on their earlier point, saying, look, claims 1 and 15 were already invalid because of the prior art we showed you, and these amendments you're proposing, they don't fix that underlying problem. The patent would still be invalid even with these changes.
So patching it up won't work if the foundation is bad. Makes sense. Third objection.
Third, they claimed Timrite had failed to provide full reasons. The law requires the patent holder to properly explain why each specific amendment is necessary and justified. Vesper argued Timrite hadn't done that adequately.
Right, just saying to better define the invention might not be enough detail for the court. And the fourth one, you mentioned it was striking.
Yes, the fourth one. Vesper accused Timrite of culpable delay and reprehensible conduct. This is a serious one. They argued Timrite had waited too long, culpably delayed, in seeking these amendments, especially since they knew about some prior art back in 2016. And they accused Timrite of acting in malafide, that's Latin for bad faith.
Bad faith. How so?
Vesper's argument was that Timrite acted in bad faith by sending those aggressive letters of demand, threatening legal action based on a patent that Timrite should have known, or at least suspected, was potentially invalid, especially in light of the prior art.
Wow. Culpable delay, bad faith.
Yeah.
Those are pretty strong accusations to level in a patent fight. It brings in an ethical dimension, doesn't it? beyond just the technical arguments.
It absolutely does. It raises questions about how parties are conducting themselves during the litigation process. These kinds of arguments can definitely influence a judge's view, especially when it comes to things like who pays the legal cost or even how the judge exercises their discretion on procedural matters.
Okay, so Vesper fires back with these 4 big objections. Now, Timrite is facing opposition not just on the non-infringement claim, but also on their attempt to amend the patent. What did Timrite do next?
Timrite tried another strategic maneuver. Faced with these objections in the amendment application, they raised what's called a preliminary point. They essentially argued to the judge, hey, hold on. 2 of these objections, the continuing invalidity one and the culpable delay bad faith one, shouldn't even be decided here in this amendment application.
Why not? Where do they think those should be decided?
Timrite argued that amendment proceedings are supposed to be relatively straightforward and quick. They suggested these more complex issues, the ones about the patent's underlying validity and their own alleged bad faith, should be deferred. Pushed off, basically, to be dealt with later in the other pending case, Vesper's original declaration of non-infringement application.
So trying to split the issues. Keep the amendment hearing focused only on, say, fair basis and reasons, and leave the tougher validity questions for the main event.
Exactly. They wanted to streamline the amendment process.
And Vesper's response to that suggestion?
Unsurprisingly, Vesper completely disagreed. They fired back, insisting that all 4 of their objections should be decided right here, right now, in the context of the amendment application. No deferrals.
Okay, so now the judge has this critical procedural question to decide before even getting to the substance of the amendments. Should some of Vesper's objections be postponed, or should everything be tackled together now?
Precisely. And this wasn't just a minor procedural point. It set up a central strategic dilemma for the judge. How do you manage these 2 interconnected legal battles, the non-infringement case and the amendment case, efficiently and fairly without prejudicing either side?
Yeah, because the timing really matters, doesn't it? Deciding something in one case could lock in an outcome for the other.
Absolutely. That's where concepts like issue estoppel come in, which we'll get to. The timing of when and where these arguments are heard is crucial to the overall legal strategy and the final outcome.
So, the Judge Stridham AJ, had a complex decision on his hands. It wasn't just about Timrite versus Vesper. It involved interpreting the court's own powers and looking back at previous important patent cases, like Antel and, significantly, Deaton.
Yes, the Deaton judgment was key here. And Judge Stridham took time to clarify what the Deaton approach actually means, because apparently it's often misunderstood. He explained that Deaton wasn't simply a rule about courts avoiding complex issues during amendment proceedings just because they're complex. That wasn't the point.
Okay, so what was the point of the Deaton approach then?
It was more nuanced. It was about avoiding duplication of effort and, importantly, avoiding that legal trap of issue estoppel. Issue estoppel is where a finding on a specific legal or factual point in one court case becomes binding in any subsequent case between the same parties. You can't re-argue that exact point later. So the Deaton idea applies mainly when issues like the overall validity of a patent are already being fully argued and decided in another case, like Vesper's non-infringement action. And crucially, those validity issues are discrete or separate from the specific amendments being proposed.
Discrete meaning the validity challenge doesn't directly relate to the actual changes being made in the amendment.
Exactly. If the validity challenge is broad, attacking the whole patent, and the amendment is just fixing a typo, maybe you defer the broad challenge. But if the validity challenge targets the very thing being amended, they're not discrete. And the judge also emphasized that under the Patents Act, Section 51(9), the court actually has very broad discretion. It can deal with an amendment application as it thinks fit. There's no rigid rule-forcing deferral.
Okay, so the judge has this broad discretion, but needs to apply the Deaton reasoning correctly. How did Judge Stridham apply it to the specifics of Timrite and Vesper's situation?
He applied a careful 2-condition test based on that Deaton logic. First, he asked, are the issues Vesper raised actually discrete from the amendments Timrite wants? Specifically looking at the continuing invalidity objection, the judge found, well, no. Vesper's invalidity arguments were aimed directly at claims 1 and 15, the very claims Timrite was trying to amend. So these weren't some general separate challenges to the patent as a whole. They were intrinsically linked to the proposed amendments. Therefore, condition 1 for deferral wasn't met. They weren't discrete.
Right, because Vesper was saying these specific claims are invalid and the amendments to these claims don't fix it. Makes sense they're linked. What was the second condition?
The second condition was, Are there other pending proceedings where these specific issues, invalidity of the amended claims, culpable delay regarding the amendment, will be fully argued and finally decided? And the answer here was also no. Vesper's existing declaration of non-infringement application was about the patent as it stood before the proposed amendments, the unamended patent. If the judge allowed the amendments now, there was no current court case set up to challenge the validity of the newly amended patent claims. Vesper would have to potentially start another legal action. Similarly, the issue of Timrite's alleged culpable delay and bad faith in bringing the amendment application wouldn't be addressed in the existing non-infringement case, which was filed before the amendment was even sought.
Ah, I see. So if the amendment got approved now, Vesper's existing case wouldn't cover the new situation, and they'd be left without a forum to raise these specific objections against the amended patent. That seems unfair.
Exactly. It would create procedural unfairness and potentially lead to more litigation down the line, not less. And there was another fascinating overlap the judge highlighted. Remember Vesper's first objection to the amendment, lack of fair basis?
Yeah, that Timrite was trying to add new stuff not in the original patent.
Right. That objection turned out to be deeply intertwined with Vesper's main argument in their non-infringement case. For example, a core part of Vesper's non-infringement argument was that their Vesper bag didn't have a strap as defined in Timrite's original patent because its internal dividing panel was structurally quite different. But Timrite's proposed amendments introduced new claims, talking about things like a reinforcing web constituted by a layer of fabric, and how the internal divider could be this web. These amendments seem designed to directly counter Vesper's non-infringement argument about the strap.
So ruling on whether the amendments had a fair basis would essentially involve deciding if those new descriptions were properly part of the original invention, which sounds very close to deciding whether Vesper's bag infringes the potentially amended definition.
Precisely. The judge realized that if he made a ruling now on the fair basis of the amendments, that ruling could, because of issue estoppel, effectively decide a central part of Vesper's non-infringement defense before that defense was fully heard in the main non-infringement case. He used the word usurp. A ruling on fair basis here could usurp Vesper's grounds in the other application. It would shortcut the proper process.
Okay, so given all these overlaps, the lack of discrete issues, the risk of prejudicing Vesper's other case, and the principles of judicial discretion, what did Judge Stridham AJ decide to do?
He issued a very clear and decisive order considering everything.
And the order was?
First, Timrite's application to amend patent number 201 SANO 006044 was postponed, put on hold. Second, he ruled that the amendment application may be set down later to be heard at the same time as Vesper's pending declaration of non-infringement application. That's case number 2023-063620. But that would be subject to the discretion of the judge handling that application. Third, he said alternatively, if it's not heard simultaneously with the non-infringement case, then the amendment application shall not be set down for hearing before a final decision has been made in that non-infringement case. So basically, deal with the original dispute about the unamended patent first, then maybe consider the amendments, and finally, the question of who pays the legal costs for this amendment application was reserved, meaning it would be decided later.
Right. And you mentioned something about a judge's postscript.
Yes, and it's quite a human touch. The judge added a note at the end, candidly apologizing for a significant delay about 6 months, from December 2024, when the hearing finished, to June 2025, when the judgment was delivered. He explained it was due to an administrative oversight where the digital case file wasn't correctly flagged for judgment writing. It's just a reminder that behind all this complex law, there are human processes and sometimes administrative bumps in the road.
Definitely a human element. So looking at the core legal outcome, what does this ruling really mean for Timrite and Vesper in their ongoing battle? It seems like a win for Vesper in this round, procedurally at least.
Procedurally, yes. The judge's decision was fundamentally about ensuring fairness and managing the court's process efficiently. It prioritized dealing with the existing dispute in a logical order, preventing Timrite from potentially using the amendment process to sidestep or undermine Vesper's established non-infringement case. For Timrite, it meant their attempt to quickly shore up their patent in direct response to Vesper's challenge was stalled. They couldn't get a potentially quick fix. For Vesper, it meant their central arguments that they don't infringe the original patent, and that the original patent might be invalid would be heard first in the main non-infringement application without being preempted or complicated by a premature ruling on the amendments. It really underscores that in patent litigation, the how and when of legal arguments can be just as critical as the what. Timing and procedure are key strategic elements.
So, stepping back from the specifics, what really stands out to you about this particular deep dive? What's the bigger picture here?
For me, this case is just a fantastic real-world illustration that these legal fights, especially in IP, aren't simply about determining who's technically right or wrong about an invention. It's so much more complex than that. It's this intricate dance, this choreography involving court procedures, savvy strategic maneuvering by the lawyers, and these fundamental judicial questions about the right time and the right place to decide specific issues. It's truly a high-stakes game of legal chess.
Absolutely. And for you, our listener, I think this deep dive really hammers home why understanding these nuances, how courts actually manage complex, overlapping cases is so important, especially in the world of intellectual property, where the stakes are incredibly high. It's a powerful reminder, isn't it, that sometimes these huge legal battles, potentially worth millions, can be won or lost not just purely on the technical merits of the patent or the product, but on those crucial strategic decisions about when and where those merits get argued. Think about that, how a single procedural ruling, like the one Judge Strida made here about deferral, can fundamentally shape the entire path and maybe even the ultimate winner of a massive commercial dispute. That's a profound lesson in legal strategy itself.